Good evening, friends. In continuation of our discussion on the right of lien exercised by the bankers, we have seen section up to section 170 of the Indian Contract Act. Then I will now carry forward with regard to the provision under section 171 of the Indian Contract Act, which contains the necessary provisions, as I told you earlier, that this is applicable to bankers, factors, wharfingers, attorneys of high courts, and then policy brokers, where in the absence of a contract to the contrary, they can retain as a security for a general balance of account any goods bailed to them, but no other person, in fact, has a right to retain or detain the goods and then as a security for such balance goods bailed to them unless there is an express contract. Then, friends, section 172 speaks of a pledge. According to this, the bailment of goods as security for payment of debt or performance of a promise is called a pledge. The bailer is in this case called the pawner. The bailee is pani, banker is a pani, and the customer is the pawner in this case. Then section 173 of the Indian Contract Act deals with the provision that the pani may retain the goods pledged not only for payment of the debt or the performance of the promise, but for the interest of the debt and all necessary expenses incurred by him in respect of possession or for the preservation of the goods pledged also. This is another important aspect. Then under section 174 of the Indian Contract Act, the pani shall not, in the absence of a contract to that effect, retain the goods pledged for any debt or promise other than the debt or promise for which they are pledged, but such contract, in the absence of anything to the contrary, shall be presumed in regard to subsequent advances made by the pani. This is the most important aspect, that it specifically, if the pledge is for one particular purpose, the other advances, unless agreed upon, cannot be made part of it. Then, friends, section 175 of the Indian Contract Act says that the pani is entitled to receive from the pawner extraordinary expenses incurred by him. Then under section 176, if the pawner makes default in payment of the debt, the performance at the stipulated time or the promise in respect of which the goods were pledged, the pani may bring a suit against the pawner upon the debt or promise and retain the goods pledged as a collateral security, or he can sell these particular things pledged on giving the pawner reasonable notice. If the proceeds of such sale are less than the amount due in respect of the debt or promise, the pawner is still liable to pay the balance. If the proceeds of sale are greater than the amount so due, the pani shall pay over the surplus to the pawner. Notice is very important here. Under section 177 of the Indian Contract Act, if a time is stipulated for the payment of the debt or performance of the promise for which the pledge is made, the pawner and in case makes a default in repayment of the debt or performance of the promise, then he may redeem the goods pledged at any subsequent time before the actual sale of them, even before the sale takes place. But he must, in that case, pay in addition any expenses which have been incurred for this particular conducting the sale. Then under 178 of the Indian Contract Act, section 178, where a mercantile agent is with the consent of the owner, is having the possession of the goods or the titles of the document of title as we call them, then any pledge made by him when acting in the ordinary course of business of a mercantile agent, it shall be valid if he were expressly authorized by the owner of the goods to make the same, provided that the pani acts in good faith and has not at the time of the pledge notice that the pawner has not authority to pledge. He has no authority to pledge, I can say. As per the explanation in this section, the mercantile agent and documents of title shall have the same meaning as it is defined in the Indian Sale of Goods Act 1930. Then, friends, section 178A says when the pawner has obtained possession of the goods pledged under a contract voidable under section 19 or 19A, but the contract has not been rescinded at the time of the pledge, the pani acquires a good title provided he acts in good faith and then he is not having the notice that the pawner's title is defective. Then section 179 of the Indian Contract Act, the pledge is concerned where pawner has only a limited interest. Then where a person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that limited interest only. It can't extend to the whole property which is under pledge. Under Section 180 of the Indian Contract Act, if a third person is deprived of, in fact, but wrongfully deprives of the bailee of the use of possession of the goods bailed or does them any injury, the bailee is entitled to use such remedies as the owner might have used in the like situations. If no bailment has been made and either the bailer or the bailee may bring a suit against the third person for such deprivation or injury. Then comes Section 181 of the Indian Contract Act, dear friends, where it is related to apportionment of relief or compensation obtained by such suits. According to this provision, in fact, whatever is obtained by way of relief or compensation in any such suit shall, as between the bailer and the bailee, be dealt with according to their respective interests. So, friends, with this particular background, we conclude our introduction on this particular right of lien of the bankers. Then in future sessions, we'll deal with the features of bankers' general lien and then the set off of customers, bankers' claims, and how these things will be dealt with. We will deal in, because what all we have discussed would be one full 25 marks question. I am dividing my lectures, in fact, with regard to topic wise, so that for examination point of view also you will get the right answer for that. So next time I will deal with the features of bankers' general lien, and then on that basis I will discuss about several important English and then Indian cases. Then the set off will come into picture later on. With this background, we conclude our session, my dear friends. Thank you very much, and then good night. We look forward to meet you again.